Hi guys, I'm back for the second lecture for this week. So in the last lecture, we talked about warrants and the constitutional requirement for warrants. This week, we're going to talk, or this lecture for this week, we're going to talk about executing that warrant, okay? So we're going to talk about what are some of the rules for executing warrants. So I'm going to share my PowerPoint with you and we'll work our way through it. Okay, so like I said, we last talked about warrants and we went step by step through the Fourth Amendment and what was required by the Fourth Amendment for warrants. So today we're going to talk about executing those warrants, which basically means serving the warrant and conducting the search and gathering the evidence. Okay, so when I say execution of the warrant, that's what I mean, serving the warrant and conducting the search. So just like we said in the last class, when you're so to get to the Fourth Amendment, we first have to determine if the area is protected, either expressly or under the expectation of privacy test. Once we get past that, then we actually start the Fourth Amendment analysis. And remember, the first question was, is it a search? And that's what we covered last week. And then we moved on now, if it is a search, is it reasonable? And that's where we left off. So remember, we said a search will be reasonable if there's a warrant and valid execution of that warrant, or there are valid exceptions to getting the warrant. So in the last lecture, we talked about having a valid warrant. What about that? So now this week, we're going to talk about the execution of that warrant. And then next week, we'll move on to exceptions to warrants. So just a quick reminder, always get a warrant. You always want to make sure that you get a warrant, because if you get a warrant and you execute it, it's always a really good precursor to think that, yes, it's going to be reasonable. The courts are going to more likely find it reasonable. Oh my gosh, sorry. They're always going to be more likely to find that it's reasonable if you actually have a warrant. Okay, so now let's talk about the execution. So even if you have a warrant, you still have to properly execute that warrant. So let's talk about what are the requirements for the execution of the warrant. So police get a warrant for a suspected drug dealer, enter his unlocked house without knocking. Is that a reasonable execution of a warrant? So they get the warrant, they show up at the door, and instead of knocking or anything, they just bust right through the door. They say, oh, we think he's selling drugs. We don't want to knock, let him know. He'll be caught, getting rid of the drugs. So we're just going to walk right in without actually knocking. And the court had to review that and determine, would that be a valid execution of the warrant? So even though we have a warrant, which is a good step, we have to carry out the execution of it in a constitutional way. Is it constitutional just to walk in without knocking? So this came up in Wilson versus Arkansas, okay? And what the Supreme Court said was that police must knock first, okay? So police must knock and announce their identity before they enter a dwelling, even if they have a warrant. Now, you could just be like, knock, knock, police, but you have to somehow identify yourself before you go in, okay? That's a knock and announce warrant. They did allow for exceptions to no knock warrants. I'm sorry, they did allow exceptions to not knocking. They said, if you could prove to a judge that if you knocked, somebody could be injured, including the police, that the person could escape from arrest, or evidence could be destroyed, the court may allow you to enter without knocking. But you have to actually apply for that. And that's what we call a no-knock warrant, okay? So for a no-knock warrant, you have to ask the judge specifically why you want it, and you have to provide one of these three reasons to get that no-knock warrant. So the police don't just get to decide off the top of their head when they're standing at the door, we don't want to knock because we think it. You have to apply for it when you apply for the warrant, and the judge has to approve the no-knock warrant, okay? So of course, there's always a follow-up exception or rule. So then what happened is they went to court and they said, come on, If it's drugs, we shouldn't even have to ask for it. We should automatically, if we're doing a drug arrest, just automatically get a no-knock warrant, because people are going to flush drugs and it's going to be hard to get them. So the court should automatically give us a no-knock warrant. Supreme Court said no. Okay, so even in drug cases, you have to apply for and request a no-knock warrant. Otherwise, you have to knock and you have to announce. Okay, so once they knock, the next question is, how long do they have to wait before they can go in? And that was the next question. So the police knocked and said, police, and then busted down the door. And the person was in the shower and didn't even have a chance to get out of the shower and answer the door. So it went to the Supreme Court, and the Supreme Court had to decide, how long does that knock and announce that you have to wait before? Okay, so that was the next question that went to the Supreme Court. And this came up in the case of U.S. versus Banks. And what the Supreme Court said is that you have to knock and announce, and you need to wait around 15 or 20 seconds before you can enter. You have to give them some time to be able to answer the door. And that seems pretty reasonable, to stand up and walk to the door. But if you're a police officer and somebody could be dangerous on the other side, knocking and announcing for 15 to 20 seconds could be a long time. I mean, time 15 seconds, it can last pretty long. But that is what the Supreme Court said. So you have to knock and announce unless you specifically request a no-knock warrant. And if you have a knock and announce requirement, once you knock and announce, you need to wait about 15 to 20 seconds. Okay? So then the next question said, what if the knock and announce rule is violated? What are the consequences for police violating the knock and announce rule? What if they don't wait 15 to 20 seconds? What if they don't knock and announce? Does that mean every piece of evidence, the arrest, everything after that is bad and is going to get thrown out? How far are we going to go with this knock and announce rule? So that came up in the next case, which was Hudson versus Michigan. And the Supreme Court said, we're not going to consider that a fundamental violation of the Constitution. So even if police violate knock and announce, we are not going to exclude the evidence. So really now there's not really any severe consequences to the police for not knocking and announcing. It's sort of like, bad officer, don't do that again. But there's no constitutional requirement. So there's no exclusionary rule. That exclusionary rule would not kick in. It wouldn't exclude all the evidence. So how do you explain these cases? Well, we talked about before, it's sort of the pendulum swinging in the Supreme Court. The earlier knock and announce cases, they were more individual rights types of cases where they wanted people to have more individual rights. By 2006, we had a much more conservative court that was siding much more towards police power. So you started to see a eroding of the knock and announce rules. So although we still have the rule, we aren't going to have severe consequences for police for violating that rule. So can the police damage property when entering the house to serve a warrant? So when they go in the door, they knock and announce or don't knock and announce and bust in the door. What happens if they damage the door, the window, anything like that when they're serving the warrant? Is that a constitutional violation? And the court said, well, it's not really a constitutional issue. It's not, it's immaterial basically to the Constitution. We're really just going to look at knock and announce. So what would happen if you damage something? The people who own the property that was damaged can sue the department and ask for it to be refunded, but they're not going to have constitutional exclusionary rule consequences for violating that property. We're not going to go that far. Can police detain people as needed while serving the search warrant? So they knock on your door and you're home and they want to go in and search. Do they just have to allow you to roam free around the house when they're searching? Or can they kind of detain you and keep you away from everything while they conduct the search? And that came up in Michigan versus Summers. In Michigan versus Summers, they said this, the search warrant does allow a limited detention of the occupants while they conduct the search. And they did this for many reasons: to protect the safety of the officers, to protect destruction of evidence, to protect the people that are in the house. So they're going to allow you, the police, to detain the people in the house for a small period of time, kind of keep them away while they conduct the search. And that is going to be constitutional. That's not going to be an unlawful arrest or anything like that. Can they handcuff you? So we now know they can detain you. Can they actually handcuff you during that detention? And that came up in Mueller versus Mena. And they said yes. If you need to handcuff them, to detain them while they're searching, you can do that. Again, for safety reasons, okay? And again, 2005, going to be much more towards police power. As long as it's limited during the time of the search, they would allow you to be handcuffed during the duration of the search. Okay, so what about this? What about Bailey versus US? So in Bailey versus US, the police want to go to a house to search. So when they get there, the people that were the residents of the house that they were searching had left. They had already left, and they were kind of about a mile away, about 5 minutes away. So the police kind of followed them until they were about a mile away, and then detained them when they were already out of the house further away. So the court had to decide, can you detain them if they have already left the area? And the Supreme Court said no. You only can detain them under the Summers case if they're in the immediate vicinity of the premises that are being searched. So you're not going to be able to just follow them or go wherever they are and detain them. The purpose of the detention is to keep the officer safe, to keep the people safe, to keep the evidence safe. If people aren't even there, they're not really posing a threat at all, and you cannot detain them, okay? Now, what about searching people whom you are detaining? So the next case was a case where they went in, they were going to search a bar owner in the bar. And so they were detaining all of the patrons of the bar. And the police went around and searched each of those patrons while they were being detained. So the Supreme Court had to decide, are they allowed to search the people that they're detaining? Are they allowed to actually search them? And the Supreme Court said no. Unless you have separate probable cause, which shows that they are likely to be having something that's dangerous, then you can search, or if you have reasonable suspicion, you can at least frisk. But you have to have separate and distinct evidence that they're dangerous and they're possessing something dangerous in order to be able to search. You're not going to just be able to search them based solely on the fact that they were detained while you were executing a search warrant. Okay? The key word is no knock warrants. The key word is no knock warrants. Too far, sorry. What if they do have a search warrant and they knock and they announce and they do all the things that they do? Okay, so the next question is, where can the police reasonably search once they are executing the warrant? So think of this example. Sheriff's deputies had a search warrant to look for a rare stolen koala in the house of a local taxidermist. When serving the warrant, they looked through the kitchen cupboards where they found small bags of white powdery substance as well as a scale. They seized the items and they arrested the taxidermist for drug possession. The koala was never found. May the seized evidence be used against the taxidermist at trial? So the question is, was it reasonable for them to be searching in kitchen cupboards when they're looking for a koala? So one of the rules that we use for when executing a warrant is figuring out where exactly the search can occur. And we use this rule called the elephant in the box rule. The elephant in the box rule says you can only look in places where the item is reasonably likely to be found. So if you're looking for an elephant, you're not looking in a small box, right? A big elephant's never going to fit in a small box. So when we go back to our example, if you're looking for a koala, it depends how big it is. If it's a big koala, then you're not going to find it in kitchen drawers. Maybe it would be in a cupboard, but it's not going to be in kitchen drawers. So that's what you have to evaluate. What are you looking for and where could it be? If it's too large to be where you're looking, then that is going to be an unconstitutional search. You can't look in places where it is unlikely to be. So you have to keep the scope of your search within the range of what you're actually looking for. Now, the last couple things I want to talk about are special search circumstances. So these are when you're conducting a search, but there are some special considerations that you have to keep in mind. So the first one we're going to talk about is bodily intrusions. Okay, so you remember Roshan? We briefed that court case, the Roshan versus California case. They broke into his house, went to arrest him. He swallowed the pills. They forced him to regurgitate the pills. So hopefully you remember the court said the standard is when something is shocking to the court. If it's shocking to the court, it's going to be a violation of the 14th Amendment. They said forcing Roshan to vomit the pills at the hospital was shocking to the court. So now we're going to use that standard to evaluate whether other bodily intrusions would be unconstitutional. So what about if we were requiring surgery to remove a bullet? So Winston versus Lee, the defendant was arrested. There was a shooting at like a convenience store and the owner said he shot the suspect. They go to the hospital, they find the suspect and the bullet's still in the suspect and the suspect says, yeah, just leave it. You're not going to get it out of me. I don't want you to use it as evidence against me. So he won't let them do the surgery. So it goes to the Supreme Court and the Supreme Court has to decide whether or not they're going to force the defendant to undergo surgery to remove a bullet. Will the warrant go that far? So analogous to Roshan, it's requiring the defendant to undergo some sort of a procedure to remove evidence or to get evidence. Distinguishable because this is full-fledged surgery, okay? This isn't just regurgitating, this is requiring the person to undergo surgery. The Supreme Court said it can only be required if, number one, you have a warrant, so you must go and get a warrant, and if the suspect's safety and privacy interests do not outweigh the need for arrest. So we always have to take into consideration the suspect's safety and privacy rights. Those are always going to most likely weigh more than the interest of evidence, unless there's some crazy circumstance where the need for the evidence outweighs their safety. You may have it where it's not unsafe and they may be able to do something, but you always have to take into consideration the safety of the person that is undergoing the procedure. Okay, now what about electronic surveillance? So number one, what is electronic surveillance? Electronic surveillance are things like wiretaps or bugging or hacking into computers. So those are what we consider electronic surveillance. So they put a wiretap on your phone so they can record the conversation. They put a bug in something so they can hear you talking in a office or something like that. They hack into your computer to read your things. Those are all considered electronic surveillance. So the question is, are those kinds of things allowed? Like, are we going to allow that? And when are we going to allow it? Do you just need a regular old warrant for that? Is that reasonable? How far are we going to allow police to go for these types of things? Okay. And so how does that differ than regular searches? Well, because it's mostly electronic and it's interceptions of communications using some sort of electronic devices. So it's kind of even a deeper intrusion in a way, because they're actually listening to the conversations that you're having. It's not just a physically looking for items, it's trying to listen into communications. We have two main federal laws that protect these. So these definitely get protection. We've already said conversations can be protected. And so there are two federal laws that specifically govern what the police can do while they're trying to conduct these electronic surveillance. So the first was the Omnibus Crime Control and Safe Streets Act. They said you need a warrant. So you cannot do any of these types of electronic surveillance unless you have a warrant. And we're going to make the requirements to get the warrant much harsher. So you're not going to be able to just go to a judge and say, oh, we have probable cause. You're going to have a lot of evidence, a lot of proof, a lot of support for why you need these kinds of surveillance, because we don't want government listening in all the time on people's conversations. The other thing that we have is called the Foreign Intelligence Surveillance Act. This is FISA. So this is really governing more foreign communications. So if you believe that somebody's having a conversation with somebody from another country, then you can request a FISA warrant. This is really to stop terrorism and creation of terrorism in these conversations of foreigners. So usually the Foreign Intelligence Surveillance Act is used to survey foreign conversations. Now, sometimes those foreign conversations involve US citizens, and that's a whole nother issue. But generally they're trying to listen to telephone calls based from foreign people. If you want to wiretap and listen to these foreign conversations, you have to make a special application to a FISA court. So it's even a more secretive, intense court. And in fact, a lot of people don't even know what goes on in FISA courts because it's highly classified. It's meant to be for highly sensitive information. And there was some stuff that came out because Donald Trump said that they were wiretapping him. And then it came out that they were actually wiretapping Russians, and the Russians just happened to call some people that worked for Trump. So then if that happens, the US citizens' information is what we call masked, because we're not supposed to use this against US citizens. And then you could ask them to be unmasked, then the US citizen information can be released. So this was a whole issue that was going on with Donald Trump when he was running for president a while ago. And it all revolved around this. So a little bit came out about what happens in FISA courts, but they're very, very secretive. There's only certain judges that are even FISA judges. They have a special hearing, and they have to meet a pretty high standard to be able to wiretap these conversations. Okay, so let's talk about time restraint. So we have a warrant, we have a search warrant. How long are we able to execute? Is it just a search warrant that's good forever, or are there time restraints? So August 26th at 7:30 p.m., Sunny County Sheriff executes a warrant to search the premises of 5678 Cherry Lane. The defendant argued that the search warrant and its execution were defective because the warrant directed the search to be executed in the daytime, and it was executed at 7:30. The sunset was at 6:42, which was nighttime. Does that automatically make the warrant defective? So we need to know, what are the rules governing the time when searches can be conducted and how long these search warrants are good for. So we are going to use what are called the FRCP. This is the Federal Rules of Civil Procedure. So these are federal rules. Individual states have their own individual rules, which we'll look at New York. But the federal rules say once you get a search warrant, that warrant is only good for 10 days. And you might say, well, why 10 days? Because generally when you're looking for evidence, it may not be in that place after 10 days, right? And one of the things we had to say is that you had to convince the judge that it was very likely that what you're looking for is going to be in that place. After 10 days, may not be there. So you only have 10 days or the warrants are then invalid. The federal rules say that you also have to serve them in the daytime, which they generally call 6 a.m. to 10 p.m. Why? Because they don't want police harassing people in the middle of the night, scaring them, knocking on the door, having them be shot at because the police people don't know it's the police. So just to make it safer, we want to make sure that those searches are conducted during the daytime. Now, is that an absolute rule? No, it's not an absolute rule. You are more than welcome to ask the judge if you can execute the search outside of those times. But it's a special request, and you have to convince the judge that you need to search outside those times, okay? Now, once you begin the search, how long are you allowed to search? Well, you're allowed to search until you find the objects. So if there's something in the warrant specifically, I'm looking for this cup specifically. Once I find this cup, search is over. I cannot keep looking. I have to end the search when my items were found. Now, if I don't find them, and I leave, I can't just come back on the same warrant. I'll actually have to reapply for a full new warrant to come back to the place again, okay? And you'll have to have your reasons of why you need to come back. So those are kind of some of the rules of the execution of the warrant. Now, what if the defendant wants to challenge the searches? They think that the police did something wrong. Well, if there's no warrant at all, let's say that they search without a warrant, and they say there's reasons why they needed to do that. The defendant can challenge that in what we call a map hearing. Map hearing is to make sure that probable cause existed, because you need, even if you didn't have a piece of paper as a warrant, you still needed probable cause. So the defense can ask for a map hearing. The judge will have to listen to what the probable cause is that the prosecutors or the police that they have, and make a determination. If there is probable cause and a valid reason why they didn't have a warrant, they're probably going to allow the evidence after the map hearing. But if they decide there was no probable cause, the evidence most likely would be excluded under the exclusionary rule. How do we know there was probable cause when there was a warrant? Because they've already a warrant. Once you have a warrant, a judge has already reviewed it and said there was probable cause. So a map hearing is only when you don't have a warrant, because if you have a warrant, a judge has already reviewed that application and determined that there was probable cause, so you can sign the warrant. New York, you also can ask for what's called an Alphanido hearing. An Alphanido hearing is going to challenge the truthfulness of the allegations made in the application for the warrant. So part of the warrant application is the police officer swearing of all these facts that they know that equal probable cause. So the police have to list and identify all the things that they think add up to probable cause. Well, if the defendant thinks the police are lying and that those things aren't true, the defense can ask for this Alphanido hearing, and then the prosecutor will have to prove that the allegations in the warrant are in fact true. And if they're not, then it's an invalid warrant and the evidence would be excluded. Okay, so what I have done is I created this little video. It's called Dallas SWAT Serving a Warrant. If you want to have some analysis of it, you can watch the video and then answer these questions. Why do you think the officers might prefer a search warrant for narcotics? What do you think the Supreme Court would say about this search warrant execution? What do you think about the execution of the search warrant? Okay, so watch the little video. It's a pretty short video, and do some analysis. What do you think? How do you think Dallas did in this serving of a warrant? Did they follow the federal requirements for a warrant? The next thing is I posted New York criminal procedure law problems. So I was giving you all of the federal rules. What you need to know are what the New York state rules are. So I posted a series of questions or problems, like what is the time limits for searching in New York? How long are search warrants valid in New York? So you want to know New York rules. So make sure you look at these problems. They're just questions. Make sure you look through your criminal procedure law and you answer those so you know specifically what's required in New York. And then I posted the search warrant. So I mentioned this in the last class. I posted a sample search warrants. The front page is one document, the back page is another. I gave you a little scenario so you can try to fill out the search warrant. So first you're going to identify what you're searching for. Then you have to decide where you're searching. Use the bottom part on the front is going to ask you for your probable cause. So if you had to swear to the judge what evidence you have that equals probable cause, you need to describe it there. When you flip it over, you need on the top, you're going to need to explain where you got that information that you're basing it on. So when you list your probable cause, you need to tell the judge where you got that probable cause. And then there's two smaller sections you'll see. You'll see a no-knock section. That's where you would request for a no-knock warrant. And there's another section where you could request to serve the warrant, execute the warrant outside the normal time. So if you feel it's necessary to execute a warrant at nighttime based on the dangerousness of the search or for whatever reason, again, you have to request that specifically from the judge and ask to execute that warrant outside those time periods. Okay, So that is what I posted. And the last thing I posted, a little like search warrant affidavit. That's just for you to review the affidavit and see, what do you think of that? If you're the judge, would you sign the warrant to search in those places? What are some of the problems? What are some of the issues? What do you think about those things? Okay. So that is the end of the execution of search warrants lecture. If you have any questions, please reach out. I'll be happy to help you, just like always. Otherwise, I will see you next week. Thanks. Hi, the key word is particularity. The key word is particularity.